Welcome back to the channel. What is going on with the Going Zone with YSL? Well, we're going to start off with Steele, Young Thug's attorney, beat Glanville in court yesterday with the Supreme Court. They dismissed Glanville's threat against Steele for the contempt order. And they also have a problem with what Glanville did with the ex parte. Let's get straight into it. Please hit the like button, please subscribe, turn on your notification bell so when I get the drop, you get the drop. And thank you for tuning in. Let's get it.
Go ahead. The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question.
And
how did you find out about it?
I'm going to ask you a question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just entitled. Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and the others have met with me, it's those ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why would you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well listen, if you don't tell me how you... and you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever. It's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a party?
Yes.
A witness who was sworn in Friday? The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland...
Tell me how you got the information.
Listen, what do you want to do?
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It
I was
concerns
told-
me that you have proprietary information.
Why is it
or
proprietary?
information that should not be having, that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's-
this honorable court,
Okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I
I'm
still
doing what
want to know,
everybody should do.
how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who this. Tell me who this
I
information
don't
is
want to
from.
be held in contempt.
Well,
I'm not
then,
answering that question. That's attorney-client privilege information. I am not answering.
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me
Don't
who
have
it is,
to. I'm
if
gonna
you don't
keep-
tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, you know, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements admitted to killing Donovan Thomas and was. Don't take my notes. No.
Decided October the 22nd, 2024, Steele versus the state. A trial court found attorney Brian Steele in contempt of court for refusing to tell the court how he learned about the court ex parte hearing with a witness and prosecutors in a case in which Steele is representing one of the defendants. Steele appealed from that contempt order, arguing that the evidence did not support a contempt finding because he did not interfere with the court's administration of justice. His information was protected by attorney-client privilege, and due process required the judge to recuse from the contempt proceeding. Because the court delayed punishment, the alleged disobedience was directed toward the court, and the court was involved in the controversy. That formed the bias of the contempt due process, required the judge to recuse from the contempt proceeding. We therefore reverse the judgment of contempt imposed by the trial court. So, Brian Steele won his case against Glanville. Glanville was wrong per the Supreme Court. Another probation revocation. Co-defendant Anthony Sumlin, aka Obama, is alleged to have been caught shoplifting in August, violating his probation. The state is now asking Judge Whitaker to revoke his probation. Obama was expected to be called as a witness in the near future. But how would this affect the trial? If probation is revoked, Obama will probably already be on thin ice and careful to conform to the terms of his plea when testifying. But if it's revoked, his testimony will be very interesting. Also, keep in mind, I think there's a good chance the probation officer proactively made this petition on their own when they saw someone commit a new offense. But see, the prosecution might not have even knew this was happening, and now this damn PO is messing up their strategy. Let's continue. State of Georgia versus Antonio Sumlin. Now comes Lindsay Evans, DCS officer, in the name and behalf of the state of Georgia, and bring this action against Antonio Smith, hereafter called the defendant, and shows that defendant entered a plea of guilty to the offense of CT1, conspiracy to violate the Racketeering, Influence, and Corrupt Organization Act, conspiracy to commit a crime, and participation in criminal street gang activity, and conspiracy to commit a crime November through December terms of 2022. That this court on the 22nd day of December did sentence the defendant to serve as following: 1.47-48 and 55, 15 years to serve on probation, all counts concurrent to count 1, with the following special conditions. You shall abide in full by each and all the terms of this negotiated agreement that you and the state agreed to. Defendant's failure to abide by any terms of this agreement shall constitute a violation of the agreement. You shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceedings stemming from the facts alleged in this indictment, but reserve your right to assert your Fifth Amendment privilege against self-incrimination. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledged that each and all the statement contained within the related to the case, defendant acknowledged that each and all the statements contained within the defendant's factual acknowledgments section of this agreement are true, and the defendant shall testify about no gur during the terms of this sentence or any time thereafter, unless your rights to do so is restored. You shall not commit no crimes. Additionally, plea terms: curfew 10 p.m. to 6 a.m. unless you are working in school or emergency or CESIS. No contact with any other co-defendant on this indictment except through counsel. Reserve your right to assert your Fifth Amendment privilege against self-incrimination. Your probation may be your probation may be suspended after 5 years, providing that you do not violate the terms of this agreement and violate no laws. Your probation may be terminated after 10 years, providing that you do not violate the terms of this agreement and violate no laws. That this court, by proper order, however, permitted the defendant to serve said sentence on probation, the terms and conditions of which are fully set forth in the copy of said sentence, which is attached hereto, marked as Exhibit A, and specifically incorporated herein. The defendant has violated the terms and conditions of probation in the following particulars. Condition 1. Do not violate the law of any government units. Special conditions: you should not commit no crime, acts on or behalf 8824. The defendant committed the new offense of theft by shoplifting, which is a misdemeanor in DeKalb County, Georgia. Special conditions: pay court-ordered monies and fees as directed. The defendant currently owes $545 in fees. Last payment made was on 5/24/24 in the amount of $50. Whereas the state of Georgia prays that the citation for revocation of probation be served on the defendant, and that the defendant be directed to appear before this court on a day to be fixed by the court, and at that time to show cause why probation should not be revoked. This was done on October the 15th.